Thank you for joining us on Heritage Events Live. We're delighted to welcome you to Supreme Court preview of the 2021-2022 term. Please welcome our host, Zach Smith, Legal Fellow in the Heritage Foundation's Meese Center. We hope you enjoy the program.
Good afternoon. Thank you for joining us today for the Heritage Foundation's annual Supreme Court preview. We appreciate you joining us whether you're here with us in person or whether you're joining us online. My name is Zach Smith, and I currently serve as a legal fellow in the Meese Center for Legal and Judicial Studies, where, among other duties, I co-host our weekly Supreme Court podcast, SCOTUS 101, along with my colleague, Giancarlo Canaparo. The court will begin hearing oral arguments in its upcoming term next week. This will be the first time the justices will hear in-person arguments since the beginning of the COVID-19 pandemic. It will also be the first time that Justice Amy Coney Barrett will hear in-person arguments. And just to keep things interesting, the justices will also be experimenting with a new oral argument format. On top of that, the court has already agreed to hear several important cases involving issues such as gun rights, abortion, and religious liberty, just to name a few. To help break all of this down and preview what the court will be up to this term, I'm pleased to be joined today by two former Solicitors General, the Honorable Paul Clement and the Honorable Noel Francisco. Neither really needs any introduction, so I'll keep their introductions relatively short. First is the Honorable Paul Clement. Paul currently serves as a partner in the Washington, D.C. office of Kirkland & Ellis. Prior to that, he served as the 43rd Solicitor General of the United States from June 2005 to June 2008. He clerked for Judge Lawrence Silberman on the D.C. Circuit Court of Appeals and for Justice Antonin Scalia on the U.S. Supreme Court. He has argued over 100 cases before the Supreme Court, which is more than any other lawyer in or out of government in the past 20 years. Next is the Honorable Noel Francisco. Noel currently serves as the partner in charge of the Washington, D.C. office of Jones Day. Prior to that, he served as the 47th Solicitor General of the United States from 2017 to 2020. He has argued some of the most important cases before the Supreme Court over the past several years. As Solicitor General, he also spearheaded the government strategy to seek emergency relief in the appellate courts and at the Supreme Court when lower courts issued nationwide injunctions prohibiting important government programs. Noel clerked for Judge Michael Luttig on the Fourth Circuit Court of Appeals, and he also clerked for Justice Antonin Scalia at the U.S. Supreme Court. Please help me welcome both Paul and Noel to our panel today. And since our time is relatively short today and we have a lot to cover, I'll jump right into the cases if that's okay. And Paul, if we could start with you, if you could tell us about the major Second Amendment case the court will hear this term in New York State Rifle and Pistol Association v. Bruen.
No, I'd be happy to, and it's great to be here again and to see everybody in person here, and it's great to be with my good friend Noel. So thanks for hosting this great event. So the court has this Second Amendment case on its docket. The name may sound a little familiar because a couple terms ago, the court had another case involving the New York Rifle and Pistol Association. But this time around, the court has decided to grant what I think is really the issue that a lot of court watchers who care about the Second Amendment have been hoping that the court would review for a number of years. For at least the last several years, there has been a circuit split out there about whether the right to carry is essentially protected by the Second Amendment or whether by one form of analysis or another, states can essentially prohibit any outlet for the right to carry. And so that circuit split gave rise to the court granting this case out of New York. New York's regime, I think, is fairly typical of the dozen or so states that do strictly limit the carry right. This is just to put this in sort of national perspective. This case, as the circuit split developed, was kind of interesting because although a circuit split did develop, there's lots of parts of the country where the circuit split really couldn't develop there because carry has long been legal as a matter of state law, so there has been no reason to challenge, really no laws to challenge, and that's true in over half the country. But about a dozen states, primarily on the eastern seaboard and the West Coast, do have strict limits on the ability to carry, and New York's regime is very typical, which is essentially you cannot engage in any open carry of firearms, and you can't engage in concealed carry of firearms unless you have a license, and it is virtually impossible to get a license. And I think the single most important thing for thinking about how the court will look at this case is that in order to get a license under the New York law and some of the other state laws, you have to show to the satisfaction of a government official a justification for carrying that essentially distinguishes you from the average person. You have to show a very special need, whether it's a threat to your life, or somebody is subject to a TRO who's been stalking you. That's the kind of thing that you have to show in order to get the license, and that doesn't seem to sit very comfortably with a constitutional right that is protected to all the people. So the idea that in order to exercise your constitutional right, you have to make a showing that distinguishes you from the vast bulk of the people protected by the text of the Second Amendment, I think will be a central feature of the argument. And I think, obviously, the state has its responses to that argument. I'm representing the challengers in this case, so you can take my perspective on this with a slight grain of salt. And I do think this will be an interesting case to kind of see the new dynamic on the Supreme Court. The court had prior opportunities to review this circuit split. They passed on those opportunities to the frustration of Justice Thomas and other justices who dissented from those denials. I think the fact that the court has taken the case probably does reflect some of the recent shifts in personnel, and it will be very interesting to see how the court resolves this case. It'll be argued in November.
Great, thank you.
What I've always found amusing about these laws, like New York's, is that in order to get a license, you have to show that you're sort of in fear of being harmed by others. And so who is that most likely to be? The people who are most likely to need licenses are the ones that you wouldn't want to have licenses because they're basically criminals. So you pretty much have a very narrow group of law-abiding citizens who could get licenses, and amongst the people who will probably meet the criteria for licenses, most of them would have unsavory backgrounds that you wouldn't want to give them licenses in the first place.
Yeah, and one of the other facts about this case that I think is interesting is that the named plaintiffs in this case do have state-issued licenses for other purposes. So they have license to carry for hunting and for target practice. So you're talking about people who have, this isn't a case about background checks or anything like that. They've passed all of that. They've been licensed by the state, but they haven't been licensed for the one thing that, at least under the Heller decision, is kind of closest to the core of the right. So I think that'll be another fact that the court will wrestle with in the argument.
Great, thank you for that summary. Noel, if we could turn to you now to talk about the major abortion-related case the court will hear this term on December 1st, which is the Dobbs case, Dobbs v. Jackson Women's Health Organization.
Sure, and that's actually one of two abortion cases the court has. It's obviously the more important of the two, and it involves a Mississippi abortion law that bans abortions after 15 weeks, which is roughly when you have a fetal heartbeat. The law was obviously challenged, and the issue is, can you ban abortion after 15 weeks consistent with the Supreme Court's decisions in Roe and Casey? Now, on their face, Roe and Casey would seem to prohibit this kind of law because Roe and Casey draw the line at viability. The state can restrict abortion post-viability, but not pre-viability. And most would agree that 15 weeks is pre-viability, though I'd note that given changes in science, the viability line is a constantly moving target. So in light of this, the state decided to full-on argue that the Supreme Court should overturn Roe and Casey in order to uphold the law. I think there are a couple of different ways that the court could go in a case like this. I tend to think that there's probably 5 votes to uphold the law. They could do that by accepting the state's invitation and overturning Roe and Casey, which I think is a distinct possibility here. They could also try to say that the state law is consistent with some understanding of Roe and Casey. I guess that's possible. I haven't yet myself figured out what that argument would be given the viability line. They could do something that I would call a Casey light. They could redefine the abortion right the way that Casey redefined it, and under that redefined right conclude that Mississippi's law satisfies the redefined right. And of course, it's possible that they could just say, no, Roe and Casey are on the books, they're good law, and this statute is unconstitutional under Roe and Casey. I think some version of one of the first 3 options is the most likely outcome, and I think it's largely going to turn on whether there are 5 justices who are willing to, accept the political heat that will come from overturning a couple of cases like Roe and Casey.
Paul, is there anything you'd like to add?
No, I do think the argument here will be an interesting counterpoint to all of the sort of, public attention that's come in the wake of the court not intervening with the Texas statute. I think that there are a lot of things about that statute that made that sort of a very kind of idiosyncratic issue for purposes of trying to, get emergency relief. I mean, Noel's thought a lot about getting emergency relief from the court, but generally when you're trying to seek emergency relief, you have an enforcement agent who's the target, and with the way the Texas law was structured, that was problematic. And so I think there's just been a lot of attention on this issue, and I think the way the court approaches this case, even at oral argument, I think will be an interesting kind of contextualization of everything we've seen over the last month.
Yeah. And what makes the case tricky is that in most abortion cases in recent years, those that are defending the abortion restriction try to make the argument that, look, you don't really have to get into whether Roe and Casey were rightly decided, because under the undue burden standard, this law doesn't impose an undue burden. It's very tricky to advance that kind of argument in this case if you think that Roe and Casey drew a clean line at viability and said that it's only post-viability that you get into this undue burden standard, but pre-viability there's essentially an absolute right to abortion. If that's the right understanding of Roe and Casey, then it's hard to make the argument that has traditionally been made in recent abortion cases. So you really do either have to, I think, take on Roe and Casey head on, or argue that it should be redefined in a way that allows the law to stand. But it's trickier to argue that even taking Roe and Casey at face value, these laws ought to be upheld.
Now, Noel, you mentioned Dobbs is one of 2 abortion-related cases before the court this term. Could you briefly tell us about the other one as well?
Sure. The other one is called Cameron against EMW. And it started out as an abortion case, but it's kind of morphed, I think, more into a federalism case, pitting the state against the federal judiciary. That's where you had a Kentucky law that banned a particular type of abortions, dilation and extraction abortions. It was challenged. The named defendant in the case was the Secretary of State, but the Secretary of State was represented by the Attorney General in the litigation defending the statute. District Court struck it down, Sixth Circuit struck it down, and then the Secretary of State decided that he didn't want to continue defending the constitutionality of the law, so he essentially gave up and said, I'm not going to file a cert petition, not going to seek any kind of rehearing in bank in the case. So the Attorney General wanted to step in and continue the defense of the law, attempted to intervene as a defendant in the case, and the Sixth Circuit that had struck down the law denied the Attorney General's attempt to intervene in the case to continue defending the law. It was particularly important because the Supreme Court then decided the June medical case, where Chief Justice Roberts issued provided the 5th vote and issued a separate opinion under which the Kentucky law arguably could have withstood scrutiny, but nobody was available to file a petition in the Supreme Court and seek a GVR in light of the June medical case because the Sixth Circuit wouldn't allow the state AG to intervene. So it really boils down to whether the federal judiciary is acting appropriately when they're using these procedural limits to essentially prevent a state from defending the constitutionality of its own law. I suspect that the court is not going to have a lot of tolerance for that kind of gamesmanship.
Great. Paul, is there anything you'd like to add? Paul, if we could continue with you with our next case, Carson V Macon.
Sure. So this is one of the kind of, I think, important religious liberty cases that the court is going to consider this term. I think the best way to think about this case is it's really a follow-on to the Espinoza case from a couple of terms ago and the Trinity Lutheran case from a couple of years before that. This case arises out of Maine. Maine is sort of classically rural. And that kind of creates the dynamic that leads to the case, which is they divide the state up into these educational districts. But many of the educational districts are so sparsely populated that they actually can't sustain a high school in that jurisdiction. So they might have elementary school, but by the time it gets to high school, they don't have their own high school in the district. So the state law provides essentially state funding to go to a secondary school, either in an adjoining public district or a private school. And the availability of private schools has long been part of the program. You can even go to boarding schools and fancy places like that. But the law has long had an express prohibition on using the funds at a sectarian school. So it is expressly limited to non-sectarian private schools. And in light of the Espinoza and Trinity Lutheran cases, that kind of facial prohibition on using otherwise broadly available aid to go to a sectarian school or a religious school, and that kind of express sort of limitation of public funding to non-sectarian schools seems very vulnerable under the Free Exercise Clause and the logic of the Espinoza and Trinity cases. And the litigants here, sort of brought to the court's attention. I think this case was initially briefed before Espinoza came down, and then Espinoza came down. There was supplemental briefing on Espinoza. And the First Circuit nonetheless said that Maine's program was constitutional. Even though I think there were some pretty strong counter winds coming from the court in the Espinoza and Trinity Lutheran cases. And the principal justification of the First Circuit in upholding Maine's law was to fix on a distinction that had been drawn in various places in the Espinoza and Trinity Lutheran cases, and this is the distinction between religious status and religious use. So the idea is it's a problem to discriminate on the religious status and simply say that you can't use this funding at a particular school because it's a religious school, but it might be something different, hearkening back to a case about using public funds to get a seminarian education in Locke v. Davie. It might be different if the prohibition is based on the religious use of the funds. And so the First Circuit really focused on that distinction, and now I think the court will consider that in the context of this case. There's just two kind of interesting aspects of the First Circuit decision that I want to highlight before I talk about what I think the court is likely to do in this case. One is just as a kind of interesting little historical footnote. One of the three judges on the First Circuit panel was Justice Souter. Justice Souter has left the court but still has a statutory responsibility to sit on the First Circuit, and so he actually surfaced in this case, although he did not write the lower court opinion. And the second thing that I think is also very interesting is in the First Circuit, the Justice Department participated on behalf of the challengers in this case and argued that the Maine statute was unconstitutional. And we've seen all of the topside amicus cases come in the Supreme Court, and there is not an amicus brief with a gray cover on it. So that means the SG's office is either going to flip all the way around in the same case, or they simply won't file a brief in a case that I think normally you'd expect the United States to file a brief. So, I'd be very interested in Noel's perspective on the government changing positions, since he was criticized for doing so in a bunch of cases where the United States ultimately prevailed. But it'll be interesting to see if an amicus brief on the bottom side of the case is forthcoming and there is this kind of flip in position. It will be particularly interesting, I guess, if the Justice Department changes position, because I think they would not be doing what Noel did, which is change position and then prevailing. Because this does seem like a case where, at least to my eye, this does seem like it is largely controlled by Espinoza and Trinity Lutheran. And I guess I would say more broadly, I think it's fine to sort of use the distinction between religious status and religious use as a way to show that one case is particularly straightforward or to distinguish a prior case. But as an actual distinction that could sort of withstand scrutiny in a variety of cases, it just doesn't seem like that's the kind of distinction that could really work. I mean, presumably institutions have religious status precisely because people actually are engaged in religion in those institutions. And so sort of saying, well, it's bad if you discriminate on the status, but if you discriminate on the basis of the use, that's okay. That just doesn't strike me as a coherent distinction in the long run. And I think that's particularly true if, you keep in mind that the underlying constitutional guarantee here is free exercise. I mean, it's not, it's not by its terms just a status-based constitutional protection. It is, a robust protection to exercise your religion. So that seems like one more reason why I'd be very surprised if the court ends up affirming the First Circuit in this case.
No, would you like to add anything to that?
Only Paul's comment on changing positions. Look, I've long been of the view that if a new administration thinks the prior administration got it wrong, it's fully within their rights to change positions. But you ought not be doing that willy-nilly, because if you're constantly changing positions, it does have a destabilizing effect, and it undermines the long-term interests of the Department of Justice as an institution. So when we reverse positions, and we only did it a handful of times, I think 4 times in the Supreme Court, and as Paul noted, we won all 4 cases. I think you need to evaluate how important the issue is and how likely you are to win. Because you do expend, on behalf of the department, a fair amount of capital when you change positions, and it doesn't make a whole lot of sense to do that if you're just going to lose. So I'll be interested to see what they do in this case, Paul. I think that they're probably, I'm not at all surprised they didn't come in on your side, given the nature of the administration. I would have been surprised if they took that position. But I think there's probably a real debate going on over whether they should just sit it out and take the heat for sitting it out, or reverse positions in a case that I think they're likely to lose if they were to do so, and take the heat for that.
And Noel, if you could keep our conversation going with our next case, Ramirez V Collier.
Ramirez V Collier, yeah, so this is one of a couple of death penalty cases that together raise interesting issues, not just the death penalty, but things like religious freedom and terrorism. And in the Ramirez case, you had a death row inmate who in the death chamber wanted to have his pastor by his side to lay hands on him and say prayers as he died. And he believes that the laying of hands on him and the audible prayers while he is dying will ease his way into the afterlife. The state, blanking on this, I think was it Texas?
Yes.
Texas allows the pastor to be in the death chamber, but I think doesn't allow the pastor to be close enough to touch the death row inmate, and doesn't allow the pastor to say anything while he's in there. So just has to stand quietly by. So the inmate brought a challenge under a statute called ARLUPA. ARLUPA is essentially the Religious Freedom Restoration Act as applied to prisoners. And it has the same standard as the Religious Freedom Restoration Act. Does a state law impose a substantial burden on the exercise of religion? And if it does, does that state law satisfy strict scrutiny? That is it the least restrictive means of furthering a compelling governmental interest? And Mr. Ramirez argued that prohibiting his pastor from laying hands and voicing prayers during his execution imposed a substantial burden on his exercise of religion. His argument was rejected up the chain until it got to the Supreme Court. The Supreme Court then stayed the execution and granted certiorari. Paul and I have litigated a lot of these cases together, and I'd be interested in his thoughts. I actually think that the prisoner has a very strong argument on the substantial burden part of the test. If you believe that the laying of hands and the voicing of prayers are what gets you into heaven, prohibiting your pastor from doing that strikes me as a pretty substantial burden on the exercise of your religious beliefs. I think that the more difficult question, and one that I'm not sure that the Supreme Court is going to resolve, is whether it would satisfy strict scrutiny. That is, whether it's the least restrictive means of furthering a compelling governmental interest, where I could see at least plausible arguments that the need to maintain a secure and orderly death chamber and to carry out the execution in a safe and efficient manner maybe is enough to overcome the burden. But to me, that strikes me as the more difficult question than the substantial burden one. It also strikes me as the type of case that the Supreme Court didn't step into in order to affirm.
Paul?
No, I mean, I think Noel has, identified where I think the kind of, the tougher question and the dynamic here is. And, every time you think about these issues, we have litigated these, we've litigated them together. In some respects, so you keep, when you think about, RLUIPA or RFRA, where it applies to the federal government, or you think about, a world in which the court, overrules Smith, it always takes you back to kind of the interchange between Justice Scalia and Justice O'Connor, back in Smith. Because, one of the things that, the dynamic here is, if you have, a test where the substantial burden imposes, triggers strict scrutiny, then, Justice Scalia worried that would mean that strict scrutiny sort of gets kind of watered down in the process. And so if the court, does wrestle with kind of whether strict scrutiny is satisfied here, I think you'll see some of that same kind of dynamic at least playing around in the background. Because, I do think on the substantial burden, this seems like a particularly clear case. But, generally speaking, the court, the one thing that, both the relevant federal statutes and the court itself, has always, forsworn is any idea that they're going to sort of second guess the centrality of the belief or the rest. And the court's cases do leave open the possibility of challenging sincerity. But, other than, cases involving, the Church of Marijuana or something, I mean, the government almost never takes issue with sincerity either. And so it does put a lot of pressure on the strict scrutiny piece of the test in the end. So it'll be interesting to see how the court kind of resolves these.
One of the questions I had about the Ramirez case, it initially came to the court on its emergency motions docket, the so-called shadow docket, and was shifted over to the merits docket on an expedited briefing schedule. Do you have any thoughts on that? And if so, what should we make of that?
So I don't have any specific thoughts because I have not studied the procedural history of the case closely enough to comment on it specifically. But generally, what just thinking back to my days clerking, I actually clerked in the heyday of the Texas executions, where I think that the year I clerked, Texas executed over 50 people. And we had a lot of cases where they'd come in on an emergency basis. There was a practice where if 4 justices wanted to grant cert, often a 5th would provide a courtesy vote to stay the execution to allow cert to proceed in an orderly fashion. But sometimes it comes in on an emergency basis, and it's not an emergency in the sense that it's 9 o'clock at night and the execution is going to happen at midnight. It's an emergency in the sense that it's October 1st and the execution is going to happen on October 14th. And in that kind of context, you can, instead of granting an emergency stay, just order expedited briefing on the merits, decide whether or not to grant cert and a stay in conjunction with that. Maybe that's what was involved here, though, like I said, I'm not sure.
Yeah, and I would just sort of say that, this, I think the way the court handled this case, is sort of an illustration of the reality that, although the shadow docket, sounds shadowy at least, and maybe somewhat sinister, it really is just the way the court handles kind of emergency motions. And there's certainly, I mean, I think it's fair if you want to criticize the court for how they handle emergency motions or which cases they do, or how they handle specific cases, but you really can't criticize the idea that they have this kind of non-merits docket, because every court, and certainly every appellate court, has a variant of this, because you do have claims of irreparable injury, and you do have motions either for stays pending appeal or injunctions pending appeal, and that's just kind of the bread and butter of appellate practice. And as Noel, I think, was alluding to, it's a very common dynamic in those situations to kind of ask for a stay pending appeal, or in the alternative, highly expedited briefing, because they both sort of get at the same point, which is we just we can't brief this and argue this on the sort of normal pattern where it's going to take months and months. And so maybe this is a situation where the court, by sort of shifting this over, will help people sort of understand that the so-called shadow docket is really just a mechanism for dealing with these cases, and in appropriate cases, in alternative ways, just to deal with it with expedited briefing. But then you still have the argument on the merits.
And criticisms of the shadow docket are particularly unwarranted in the context of death penalty cases, because often the capital defendant is filing his papers in the Supreme Court, hours before his execution is to take place. And so if the Supreme Court thinks that his filings are unmeritorious, then the only option is to either just deny it without opinion, because they don't have time to write an opinion, or actually grant the capital defendant the relief that he's seeking in order to take the time to write an opinion. And I think that, given that one of the problems in this area is the gamesmanship that occurs leading up to the execution, the last thing that the court would want to do is encourage further types of gamesmanship, rather than adopting a set of rules that encourages capital defendants to bring their claims in a timely manner that actually allows for the orderly disposition of their motions.
And there is one other death penalty related case pending before the court, the United States versus Tsarnaev. Noel or Paul, do you have any thoughts on that case?
I mean, it's a huge case because it involves the Boston Marathon bombers, and particularly the death sentence of the younger brother who was involved in that vicious murder, that vicious crime. And I'd encourage you to take a look at the briefs, because when you get further removed from horrific events like that, you tend to forget how horrific they were. But the United States brief does a wonderful job of bringing back into focus what actually happened on that day and how many lives were lost and destroyed as a result of those terrible crimes. The actual legal issues are not particularly interesting. They're the types of legal issues that wouldn't ordinarily garner Supreme Court review, but for the fact that the First Circuit invalidated the death sentence in this particularly gruesome case. I think one of them involves a question about whether the trial court judge asked enough questions to prospective jurors to gauge whether they'd been exposed to too much media coverage on the case. He asked a lot of them, but the defense wanted even further and more detailed questioning. The other has to do with whether the trial court erred in not admitting a prior crime by the older brother that the younger brother thought would show that the older brother was able to exercise influence over him to coerce him into participating in the murder. These are the types of discretionary trial court decisions that don't normally garner Supreme Court review, and frankly don't normally garner reversals in the courts of appeals. But I think that given the high-profile nature of this case, given that the First Circuit seemed pretty clearly to step out of its lane in overturning the trial court on what looked like pretty routine case management decisions, the court felt like if this conviction were going to be upheld or reversed in a case of this magnitude, that decision ought to come from the Supreme Court.
Paul, if you could take our next case, it is United States versus Zubaydah.
Sure, I'm happy to, and I think I can discuss this relatively quickly. If the party's name sounds familiar to you, some of you may remember that this was one of the individuals who was accused and convicted in our military system of participating along with Osama bin Laden. He is currently being detained in Guantanamo. I see Cully's here. I remember something about almost 20 years ago when some of these issues were first arising in the Bush administration, and it's interesting that given everything that's happened since then, that we still have people detained in Guantanamo, and this case though doesn't really arise from that situation, his enemy combatant status, the process that he did or did not get through that. This case is really something that he initiated along with his lawyer, and they filed something under a civil statute, 28 U.S.C. 1782, that provides for an ability to get discovery in aid of foreign judicial proceedings, including foreign criminal proceedings. And so the theory of this action that was filed in U.S. federal court was that he needed to get discovery from some former CIA contractors about the nature of his interrogation outside the United States, and specifically some of the circumstances of where that interrogation took place and how that interrogation took place. Somewhat surprisingly, frankly, to me, the Ninth Circuit in the case that's under review here rejected the government's argument that it should dismiss this discovery-seeking action under 1782 under the state secrets doctrine. The state secrets doctrine, as many of you may know, is a doctrine that has long been a part of the Supreme Court's case law that says that when the federal government in certain sensitive areas comes in and essentially says that a certain fact or series of fact is classified or otherwise a state secrets, that the lawsuit essentially should stop at that point and cannot proceed in a way that would reveal those state secrets. Generally, when you have these state secrets at issue, it puts the government in a very difficult position, because even to say we neither confirm nor deny can already sort of be a tip, and it just makes it very difficult. So the doctrine has evolved in a way that, generally speaking, when the federal government invokes the doctrine, which they do not do frequently, courts are generally fairly deferential in reviewing it. The Ninth Circuit was not very deferential here and essentially disregarded the government's assertion of state secrets and said that the action should proceed. That precipitated, I think, 12 votes dissenting from the denial of en banc in the Ninth Circuit, and then precipitated the Supreme Court granting cert here. I don't think there's much mystery about what the Supreme Court's going to do in this case. I would be, frankly, shocked if they don't reverse the Ninth Circuit in this case. And I guess the reason I say that is, I think there are difficult state secret cases out there, but I don't think this is one of them. I mean, I think the difficult state secret cases are where somebody's legitimately been injured and they would otherwise have a sort of tort action or other action to get recompense for their injuries, and they're affirmatively stopped from getting relief that they might well be fully entitled to because the government comes in and says, we just can't litigate on this topic at all. And, I had some cases when I was in the government that fit that pattern. We ultimately prevailed in those cases, but that felt like a much more difficult argument because you were essentially taking somebody's right to compensation away from them under circumstances where the government was not at least expressly offering any alternative mode of compensation or something like that. But the fact that this arises under 1782 and it doesn't arise in the context of a tort claim or another claim for compensatory relief for somebody who's been seeking that kind of legal relief, but it's really just a request for information in the abstract in aid of a foreign proceeding. That just seems like probably the easiest context in which to defer to the government's assertion that something is a state secret. So I always hate to make predictions about cases that you're, not directly involved in, but this does seem like a very straightforward case for the Supreme Court.
Noel, do you have anything you'd like to add?
Only if you know, Paul, I have kind of a question. Is there an overlay also of, since it's information in aid of a foreign proceeding, the foreign affairs function between countries in addition to the national security function to the United States?
There's definitely sort of that overlay to it, which I think makes it an even easier case. Yeah, look, if there's anything that kind of makes this case at all hard for the government, I think it's that some of the information here that's alleged to be a state secret, has been published in a number of sources, and so I think there's this sort of feel that these really aren't secret. I read it in The Guardian or something. And, I think, though, that, I think those that have worked in the government really do appreciate that there's just a fundamental difference between a fact being reported in the ether and the United States government itself sort of confirming that fact or having it confirmed in a U.S. court proceeding. And I think that's at the heart of what the Ninth Circuit really didn't fail to appreciate in this case.
Well, in the interest of time, I'd like to skip ahead and talk about two interesting petitions pending before the court that the court was set to consider at their long conference yesterday. Paul, if it's okay, could you remind us what the long conference is and then talk about the Boardman v. Inslee petition?
Sure. So the long conference is, as its name suggests, a conference where the court gets together after their summer recess, and they spend a long amount of time together, and they have a long list of cases they're considering. During the normal sort of period of the Supreme Court term, the court hears petitions for cert alongside merits cases and alongside their other work in a fairly predictable pattern. So they get together every couple of weeks or every week. There's, maybe, half a dozen to a dozen cases that they're likely to discuss at any one of those kind of normal conferences, and then they'll decide whether to take cases from that relatively discrete list of cases. But since the court, operates under discrete terms and, does take the summer off, all of the petitions that are filed during essentially the summer get put on this one sort of, summer list, long conference for the court to consider. It's, sort of conventional wisdom among practitioners that you want to kind of try to avoid the summer list if you can, the long conference if you can. But sometimes you can't just because of the timing. And, my own view is that's probably overstated a little bit because, the court grants plenty of cases off of the summer list in the long conference, and hopefully that will be the case this term as well, since the court could use a couple of cases for the December sitting. One of them that I'd be delighted if they decided to take is a case where I filed a petition. This is a case called Boardman against Inslee, and it's a First Amendment challenge to a Washington state law that was passed by initiative. And in many respects, this case is a little bit of a follow-on to the Janus case. The Janus case, you may remember, is a case that recognized sort of the First Amendment rights of public sector unions to, not only just opt out of the public sector unions, but to basically not have to be forced to contribute to public sector unions.
One of the cases where we reversed positions from the prior administration.
Exactly, and the court overruled the Abood case in that in that case, and then that sort of created this dynamic where if you're a member of a public sector union, you can't be forced to contribute to the public sector union. In response to that, of course, the public sector unions have not said, okay, well that's fine, we'll disband. They have, they've lobbied, which is obviously their constitutional right, for various laws. And one of the laws that was passed was this Washington initiative, and it focused on a particular public sector union in a particular market, which is home care professionals. And these are people who provide care in the home for people, and they generally are eligible for reimbursement for their services through various federal government programs. And it's a kind of unique public sector context. It was the same context that gave rise to the pre-Janus case, Harris against Quinn. What makes it kind of unique is, unlike most sort of groups of employees, where, if you're thinking about like the teachers union, well, they all show up at the school, and it's pretty easy to both lobby them to join the public sector union or to not join the public sector union. But these workers are spread throughout the states, and it's very hard, even for the union itself, to know who is providing these services and who would be a potential member of the public sector union. And so Washington State passed this referendum that basically limited the ability of anyone but the union to get access to the identities of the home health care providers. And so this essentially gave a monopoly on the information and the contact information for the underlying potential union members with the unions, and left the sort of challengers essentially out in the cold as a result of this referendum. So this was challenged on First Amendment grounds. There are, it's both seems sort of discriminatory and inconsistent with the full enforcement of Janus rights. It also implicates some very interesting First Amendment doctrine that the court has developed over the years about the circumstances in which there is a First Amendment right to access to information. And so I think there's kind of two strains of a very interesting First Amendment doctrine at issue here. The Ninth Circuit rejected the challenge. It precipitated a very lengthy dissent from Judge Bress. So we'll see what the court does with it, but it'd certainly be an interesting case if the court were to grant it.
Great. And Noel, if you could tell us about one of your pending petitions, the Roman Catholic Diocese of Albany versus Lacewell.
Sure. Another one that I hope proves that it's not necessarily bad to be in the long conference. You all probably remember the various contraceptive mandate cases, the Zubaydah case, Hobby Lobby, the more recent Little Sisters case that involve government regulations that require employers to cover contraception on their insurance plans, subject to exceptions, and that includes religious employers. Well, New York has a separate law, a state law, that requires employers to cover surgical abortions as part of their insurance plan. And the only exception it has is for religious organizations that whose primary purpose is to inculcate their religious beliefs and to primarily employ and serve individuals of their own religion. So needless to say, that excludes from the exception a lot of religious employers like Catholic Charities organizations that view their mission much more broadly than simply inculcating religious beliefs, and that view is part of their religious mission, serving individuals who don't happen to share their faith. So the Diocese of Albany, along with several other Catholic and non-Catholic organizations, sued to invalidate the law. The New York State Court of Appeals, which is actually the highest court in New York, several years ago had rejected a similar challenge to a contraception mandate in New York State. So this case went to the Intermediate Court of Appeals in New York, where that court applied binding precedent to reject the diocese claims, and then the New York State Court of Appeals, the top court, denied review. So here we're seeking cert to the Supreme Court from that process. It presents a couple of different interesting issues. The main issue is the scope of the Supreme Court's decision in Employment Division versus Smith. As you'll recall, that case says that if a law is general and neutral, then it doesn't violate the Free Exercise Clause, even if it imposes a substantial burden on religious beliefs. And there's a big debate going on as to what it means for a law to be general and neutral. Our view is that here, this law actually does have an exception to it. It's got an exception for some religious organizations, but not others. That makes it a non-general law and a non-neutral law. Therefore, Smith doesn't apply, and it should be subjected to strict scrutiny. The other issue that is presented is whether, if the court doesn't agree with us on that, it should just overturn Smith. If it sounds familiar, it should. I think these are some of the issues that the Supreme Court took the Fulton case last term to resolve, but given the somewhat quirky nature of that case, the court didn't really get into the details of the doctrine. So I think this case, and I hope that the Supreme Court will agree, provides a very good vehicle to clean up an area of law that is somewhat murky. And I think the murky nature of it is underscored by the fact that New York State has multiple arguments for how under Smith this is in fact a neutral law, and they cite all kinds of cases from the Supreme Court and other circuits that show how they've applied Smith, and it simply underscores how the Supreme Court jurisprudence really is in need of a cleanup in this area. New York State pointed out in its opposition brief that they've got all different kinds of mandates just like this, whether it's for abortion or contraception and for other things. So how on earth could it be wrong? To which we, obviously responded, well, that's exactly why we need Supreme Court intervention here, because New York State has shown a penchant to trample the religious liberty of individuals for decades, and they're not going to stop until the Supreme Court steps in and tells them to stop. Notably, the basic regime that New York applies is the same regime that's applied in California. So you essentially have this bad jurisprudence in two of the nation's largest states. So hopefully the Supreme Court will see it our way and decide that this is something that they all also ought to step into and resolve.
Great. Thanks for sharing that. We have just a few minutes left in our program, and I think we have time for a couple of questions from either folks here in person or from those watching online. So if you have a question and you're here in person, just please raise your hand and we'll get someone to bring a microphone. Or if you're watching online, please feel free to submit your question and someone here in the room will forward it to us. Do we have any questions from our audience in person? Well, while we're waiting for some questions to come in, I do have one question. The Supreme Court recently announced a change to their in-person oral argument format. Noel or Paul, if one of you could maybe briefly tell us what that is and then give us your thoughts on it, if you would like.
So as I understand it, they're moving back to an in-person format, and Paul, chime in with any further details because I don't know all of the details. They're moving to an in-person format, but the attendees are going to be quite limited. It's not going to be open to the public, and there's not going to be a gallery. Rather, you'll have the justices, the necessary court staff, credentialed Supreme Court reporters, and then the lawyers that are necessary to argue the case. So you'll largely, if you can sort of envision the courtroom, if any of you have been in there, you'll largely have an empty gallery, but then you'll have the reporters off to one side, although maybe now they'll be spread out more, and the clerks off to the other side, maybe they'll be spread out more, the justices and the lawyers. But whereas you usually have a pretty packed courtroom, I think you're going to have a fairly empty courtroom. They are going to continue to live stream the audio of the oral argument. What I don't know is whether they're going to continue with the format for conducting oral argument. You may recall that when it was done telephonically, instead of the ordinary free-for-all amongst the justices, each justice, starting with the most senior and moving to the most junior, had about 2 to 3 minutes to question each lawyer, and you pretty much went right down the line. I'm interested to see if they revert full on back to the much more free and open debate that you had back when arguments were live in the courtroom.
Yeah, and I think the court's indicated that, at least informally, that they do plan to retain some of this kind of seriatim questioning, and I do think that it'll be very interesting to see how that works in practice. That was, I think, a necessary accommodation to the telephone technology. It's less clear that that's really necessary now that they'll be sort of back in person. I think, I might have guessed that they would just go back to the way they had done it, but they seem interested in retaining a degree of this kind of, structure. And, I suppose, one real advantage that we all saw to the telephonic arguments was getting to, sort of hear Justice Thomas as an active participant in the oral argument. In my case, I think I went, for about my first, 100 or so arguments without a question from Justice Thomas. And then I went 5 for 5 on my last arguments. And that was really, welcome development. And, I have to think that's kind of maybe part of the reasoning for why the court is going to retain, at least some vestiges of that seriatim format. Exactly how that all plays out in person and how it works, how it affects the length of the argument, that's another thing that I think, is going to be very interesting to see. My own sense is that this will be a little bit of a work in progress. It's not like we're going to go back and the court's going to have, kind of in-person argument 2.0, and it'll be very, formulaic, and it won't change at all. I think it's going to be kind of an evolving process. I think from the perspective of the advocates, it's kind of fascinating because for years and years and years, nothing changed. And, over the past couple of terms, we've seen kind of the advent of like a little 2-minute opening where the justices would kind of give you some uninterrupted time, which was not something we'd grown accustomed to in the previous regime. And then we had sort of the necessary changes with the telephonic hearings, and now you're sort of, going back. And I think Noel alluded to the fact that they're continuing to live stream. I assume that's principally an accommodation to the restrictions on who can attend the argument. I think from the perspective, say, of like our clients, the idea that they can't necessarily attend their own oral argument, is not something that'll, super easy to explain. And so, I think the live stream is an accommodation for that. But, if we get to a point, and I hope we will soon, where the gallery is fully open and the rest, it'll be interesting to see whether the court ever kind of walks that back, because it does seem like that's something we've now gotten quite accustomed to.
Yeah, I totally agree with that. And I also think, though, that once you start doing something like that, it's hard to walk it back. I think that's one of the main reasons why the court stuck with, 20th century technology and did telephone conferences rather than, the type of video arguments that we see in the courts of appeals. Because I think they understood that once you opened up, video of oral arguments, it was going to be much harder to walk that back. And maybe the Chief Justice just made his peace with the possibility that he would have to live with audio streaming. But I think that going to video streaming would have been a bridge too far.
And I see we have one question from we have a question from our online attendees. So if you could please share that with us.
Do either of you anticipate any of the vaccine mandate challenges getting expedited to the Supreme Court?
Oh, I mean, I could easily see it happen because, I think that no matter who prevails in the lower court, the party that doesn't prevail is going to have a pretty good irreparable injury argument. I mean, if the government loses in the district court, they're going to say, this is super important that we do this. People are going to die. We need expedited review. And if the challengers lose, they're going to say, look, I have a right to bodily integrity that's, about to be, sort of denied. So I think these are cases that are quite likely to move pretty quickly through the system. And, whether the court ultimately, takes them and exactly how quickly, I don't know, but I do think they sort of have, they have the makings of cases that will move through the system rapidly as opposed to slowly.
And I think they're structured to move quickly, at least as I understand the regime, and we're talking about the OSHA rule that is likely to come out sometime in the next few weeks. The way the statute works is that challenges have to be filed in the Court of Appeals, not the district court, and then all of the cases of all of the cases that are filed in the first 10 days, if they're filed in multiple circuits, there's essentially a lottery amongst the circuits, and whichever circuit wins, all the cases get transferred to that one circuit and consolidated, and then any cases that are filed after that 10-day window also get funneled into the same court. So it's basically structured in order to allow pretty expedited litigation of these issues.
Well, unfortunately, our time today has gone too quickly, and that's all the time we have for our panel today. For updates and information about what's going on at the court throughout its term, please feel free to listen to Heritage's SCOTUS 101 podcast. But in the meantime, please join me in giving our panelists, Noel and Paul, a hand and thank them for coming today. Thank you.